Okay, thank you again for joining our webinar today. In this webinar, we will explain what H-1B visa category requires and what the H-1B CAP process entails, what employers need to know to sponsor H-1B visas for their employees and potential candidates, and when employers need to act to ensure a smooth H-1B registration and petition process, and what important changes and updates there are about the H-1B program. We have 4 speakers today who are experts in corporate immigration. Among the 4 speakers, we are honored to collaborate with 2 highly esteemed guest speakers who will discuss H-1B from the perspectives of the employers. We have Amberley Johnson, who is a senior manager of immigration at Micron Technology, a global leader in semiconductor memory solution industry. We also have Nodira Artikova, who is a global mobility and U.S. immigration specialist at Novelis, a global leader in aluminum recycling and manufacturing industry. We have 2 speakers from Klug law firm. We are a fast-growing leading law firm in corporate immigration. Our service is based on the 3 pillar models of highest quality legal work, exceptional client service, and caring approach. From Klug law firm, my name is D Jung, and I'm a senior associate at the Houston office. And we also have Cheryl Geiser, who is a senior counsel at our Atlanta office. With that, we'll start the discussion on H-1B. And if you have any questions, please feel free to post in the chat room so we can address them during the Q&A time at the end of the webinar. H-1B is a specialty occupation visa category requiring both the position and the employee to meet the specialty occupational requirements, which we'll discuss in more detail in the next slide. H-1B is also subject to an annual numerical cap. There are total 85,000 H-1B visas available for foreign national workers each year. These include 65,000 regular cap requiring at least a bachelor's degree and 20,000 additional cap for those with U.S. master's degree or higher. There are some H-1B categories that are exempt from the cap. These include employment with institutions of higher education or with certain nonprofit entities or research institutions. If you believe that your company may qualify under these categories and would like to explore hiring H-1B workers, please reach out to us so we can assess the eligibility. Also, those foreign nationals workers who have already been counted against the cap is not subject to the cap. For example, if a company is filing H-1B extension for a foreign national who was already selected in an H-1B lottery before, that extension petition does not need to go through the cap lottery again. However, it is important to note that a foreign national worker who has been selected in a lottery has a maximum of 6 years that they can be in an H-1B status. Once the 6-year limit is reached, the foreign national cannot extend the H-1B status. There are some circumstances that the foreign national's H-1B status can be extended beyond the 6-year limit, notably including when the foreign national has obtained an I-140 green card petition approved, but their priority date is not current yet. These exceptions are important, especially if the employee is from a nation or a country that normally has long wait for green cards, such as India or China. In essence, the first H-1B petition for most foreign nationals must go through an H-1B cap lottery, but subsequent H-1B petitions for the same foreign national will normally not require going through an H-1B cap lottery again in most cases. In order to enter the lottery, the company must register the intended H-1B case with USCIS first. The registration period will normally be in March, and USCIS will normally conduct the first lottery and notify the selected registrants by the end of March or the beginning of April. The first H-1B petition filing window for the selected cases will normally run from April 1st to June 30th. If the number of H-1B cap is not reached, USCIS may conduct additional lotteries, and the second lottery, if there is one, is normally in July. To give you a sense of how many registrations were received in recent years, in the fiscal year 2024, more than 780,000 registrations were received. In fiscal year 2023, more than 480,000. And then FY 2022, more than 308,000 registrations were received. And you can see from this number that the trend shows that more registrations are received each year. This is partly due to the fact that multiple registrations are submitted for the same foreign national workers to increase the chance of being selected in the lottery. In order to prevent or reduce the abuse of the registration system, USCIS has proposed a new rule that will likely apply to this year's CAP registration, including barring multiple registrations by related entities. More updates will be discussed at the latter part of this webinar. If the foreign national has a master's degree from a U.S. institution of higher education, the person's registration will have a higher chance of being selected. Most U.S. public universities and private nonprofit universities will qualify for a U.S. institution of higher education, but some may not. Therefore, it is important to ensure the foreign national's degree was received from a qualifying institution. Can you go to the next slide, please? Now that we've discussed the H-1B registration process, we'll dive more into depth into what the requirements are for H-1B visa category. First, there must be a good faith U.S. job offer for a specialty occupational position. Specialty occupational position is one that the duties performed are complex and specialized enough to require at least a bachelor's degree or equivalent in a closely related field. It is important that the job details of the position is assessed by an expert immigration counsel to ensure that they meet the requirements of specialty occupation. Second, the foreign national beneficiary must possess the qualifications for the specialty occupational position. This means that beneficiary must hold at least a bachelor's degree or equivalent in the field of study that is closely related to the positional duties. If the beneficiary possesses a foreign degree, the degree must be evaluated by a credible agency to be equivalent of a U.S. bachelor's degree. This is especially important as some foreign bachelor's degree may be a 3-year degree, which are not equivalent to a 4-year U.S. bachelor's degree. It is also possible to use the beneficiary's professional experience in the related field to meet the degree equivalency requirement. Simply put, a 3 years of requirement is equivalent to 1 year of university coursework. Experience will again need to be evaluated by the credible agency for a U.S. bachelor's degree equivalency. Third, there is a prevailing wage requirement to H-1B. Prevailing wages are determined by the U.S. Department of Labor each year based on the occupational category and the location of employment. There are 4 levels of prevailing wage, and these 4 levels depend on the level of qualification required for the particular position. The employer must pay at least a prevailing wage as a salary to the beneficiary. If the U.S. Department of Labor's prevailing wage are not applicable, an employer may also use alternate wage surveys for the prevailing wage. Lastly, because of the prevailing wage requirement, an H-1B work authorization is specific to work location. This means that H-1B worker generally may not work outside the intended area of employment indicated in an H-1B petition. In such cases, an H-1B amendment may be required. Employers should check with an expert immigration counsel before moving an H-1B employee to another location of work or having them work remotely. Next slide, please. So now we're going to talk about who should act now to register into H-1B CAP. If your company has employees or candidates that require U.S. work authorization, you should consider entering them into the H-1B CAP registration. These employees, candidates, may include those who are F1 students on OPT or CPT to secure more long-term work authorization, candidates or employees currently working outside the United States, but their U.S. presence is needed, employees with temporary work authorization such as DACA, TPS, asylum pending, employees who are on the dependent status such as L2, E2, E3, H4, since their statuses are dependent on their spouse's status, employees in L1 status who may be maxing out in a couple of years because H-1B can be extended beyond 6-year limit in certain circumstances, and also employees in a single intent visa category such as E, TN, H-1B1, or O1, so that their ability to travel or extend non-immigrant status and work authorization is not impacted by the green card process. The next slide shows important dates to remember. And some of those dates are the March 1st is normally when the H-1B CAP registration will begin. So for the companies, definitely January and February are the months that they want to prepare the H-1B CAP registration. Normally, the H-1B registration will run until March 20th. And at the end of March, USCIS will conduct a lottery and select those who are selected in the first lottery. And once selected, the selected registrations will be notified. And from April 1st to June 30th will be the first filing window of H-1B CAP. And again, if the number is not reached, then there may be another lottery conducted by USCIS. And if there is one, normally that will be in July. We will now turn to Nodira on the topic of how companies can prepare for the H-1B season.
Hello, everyone. Novelis, I represent Novelis Global Mobility and U.S. Immigration Department. And what we normally do is we run a table of individuals, employees who would potentially benefit from H-1B lottery, from H1 switching to H-1B status. And so we maintain that list. And then around this time of mid-January, I meet with our legal counsel where we review and discuss and if a legal counsel has a few individuals that they propose to add, then we add them to the list. And then that compiled list of individuals I normally send to our HR business partners within the company, where we ask them to review and add if they have any other individuals cascaded to the plans, because Novelis, I represent headquarters in Atlanta, and we do have in North America 18 locations, plants all over the states. So the HR business partners, they cascade this information request to the plant HR leaders. So they add, if they have to add some people, then that compiled list is provided to our legal counsel on February 1st normally. And the way we do that, how we select is mostly, like David said, people who are currently on F1 either OPT or CPT EADs, and we do want to continue to employ them. So we are, foreseeing that, especially like last year, not a lot of people were selected. So and for some people, it could be critical, right? So people in F1 status, then TN people, we do have a lot of TNs who suddenly decide to localize. So then they are a potential category of employees that we put. And L1B, like David also said, it's 5 years, and we are in the process of green card, let's say, but we need that extra time to adjudicate and get to the end of the green card process. So that pretty much it. Once we hand over the list to our legal counsel on February 1st, then the immigration law firm does the work for us. I heard that some corporations do registration in-house. Thankfully, that's not our case. Our immigration counsel does our registration for us and then just beautifully notify us if someone is selected. So that's how we run.
All right, thank you, Nodira. Now we'll turn to Amberley on the topic of identifying bona fide job offer.
Yeah, definitely. And I will say, I think registering internally yourself would be crazy. We also use the law firm for registration. That is quite an adventure for someone to take that on. So identifying a bona fide job offer. So most of our registrants for the lottery are already employed with Micron. So there's not a huge difference between like if you're already employed and perhaps you're, a future new hire that might occur, after the lottery. Anytime we have, our recruiters looking at a foreign worker, once they get to a potential offer stage, they go ahead and initiate an assessment with the immigration team. That would be our in-house team. And we take a look at it, and we always verify with outside counsel. But you get pretty used to looking at them and knowing if it looks like a specialty occupation and what the degree is and kind of the ingredients, in the situation. But we do absolutely pass it by legal, our external law firm that makes an assessment on if this is a viable candidate for an H-1B and really the overall path forward for that candidate. So we don't just do it in H-1B situations. We do it anytime a foreign worker is being hired into the United States. But in this situation, we do look, if it's a student, like what's the role, what's their experience, what's their degree in, and assuming it's a specialty occupation, then, our recruiter can proceed with making a job offer and having it signed. So we do assessments, but we don't actually start work, the immigration work, and in the situation registering for a CAP unless an offer letter has been signed. And then once an offer letter has been signed, we always, just a matter of our standard practice, is to have a copy of that signed offer letter as well as a copy of the job rec that they are hired against. That goes into the file, normal stuff like the resume. But that job rec is something that we leverage as well as the offer letter to make sure that we, have consistency and really understand what the person is being hired for. So it's kind of a short answer. I don't know, David, should I add anything more?
I think that's great. So I think we can turn to Cheryl for more updates and changes in H-1B.
Yeah, so thank you, David and Nodira and Amberley, for all of your input. I'm kind of going to run through the nuts and bolts of new things happening and updates from last year for anybody who's been through this process before, or even if you haven't been and you're still referencing old information, there's a lot of new stuff. So this year, we have received notification, I think as of yesterday, that, in January of 2023, they had proposed some new filing fees. And it looks like these fees are going to change. I guess the headline yesterday was imminently, so in the next couple of weeks, which means that the current H-1B filing fee from $460 will go up to $780, which is a 70% increase. The fraud prevention and detection fee will remain $500, $1,500. And then the $2,500 premium processing fee of $2,500 will be increasing to $2,805. I don't know where they got that number, but that's the number as of February 26th. The good news is they had indicated that they would be increasing the registration, or in the proposed regulation, it did have that the registration fee was going to increase significantly, but it looks like that is going to remain at the $10. So we don't have to worry about that one, but certainly the I-129 fee is a significant increase. Who is required to pay? So in terms of the fees associated with the filing of the H-1B petition, the Department of Labor requires that the employer pay the fees. So in terms of the premium processing fee, though, I believe that the foreign national can pay, but typically employers will pay that. So they basically can't require the foreign nationals to pay for the required wage, which is something that, I think David spoke about, we would list on the labor condition application, and the attorney's fees, the fraud prevention fees, and the training of U.S. worker fee. Another update, which is just, does anybody have any input on that? Okay. So another update is when an individual is on the F1 and they're selected in the lottery, but their school or OPT ends prior to the October 1st date, which is when the H-1B will take effect, which is when the fiscal year begins, there's usually a gap. And so individuals in this status are able to continue working through that period between the end of their authorization and their new H-1B. In terms of degree requirements, this is something that is commonly asked. Everybody has to have the foreign national has to complete their H-1B credentials. So whatever degree is required for the role, they have to have it by the time the petition is filed. So, Nodira and Amberley, we talked about identifying individuals. So if you identify someone and they're going to have the degree by the time of filing, then, they can be registered. So in terms of a few things so this is a kind of a slide that talks about the proposed regulation that just recently came out with lots of changes to the H-1B program. Some are kind of already being applied by the government, but some are new. So one area where they're going to make some significant changes is related to the degree required for the role. So two things. First, they're going to require that the degree be directly related, which they've already been kind of requiring this, but now it's going to be codified. And essentially, you have to show that the person's degree is directly related to what they're going to do. And they've indicated that a general bachelor business administration degree is not going to qualify someone without some specific specialization. Similarly, like an engineering degree is not going to qualify somebody without a specialization. But the nice thing is that they have said that it doesn't, two things. First of all, it doesn't have to be one degree. So a role can require multiple types of degree as long as you can still demonstrate that it's directly related. And then the other is that they've indicated that normally, the specialty occupation rule for an H-1B is that it has to be a role that normally requires a degree. And so in this new regulation, they're talking about what constitutes normally required. And they're saying, it's something that it doesn't always have to require a degree. So if my company requires that a systems analyst have a degree, but in the industry there are companies that don't require a degree, that doesn't necessarily preclude someone from an H-1B. The regulation talks a lot about something that we've already known as a requirement, which is that if an individual changes work location, an H-1B amendment is required for that location. For the itineraries, that's typically when you're working offsite for an employer who is not, if they're working offsite at a location other than the petitioner's location, then you would have to have an itinerary for exactly where they're going and the length of stay at each work site. The F1 student I already spoke about a little bit in terms of them being able to just continue their work authorization and continue to have that while they're waiting in between the October 1st start date and the end of their OPT or school program. In terms of start date flexibility, this is related to the fact that even though the fiscal year begins October 1st, your start date for the H-1B doesn't necessarily have to begin on that date. And so there is some flexibility around that. And then it specifies what the U.S. employer is. So a few things that are going to be impacting the registration period this year is something that is very exciting, very new, is that they're going to have organizational accounts that will allow for online collaboration and submission of the H-1B registration and perhaps even the petition. So right now, you'll be able to file not CAP cases, but they're ultimately expecting to roll out the opportunity to file the CAP cases in February online, which would be very nice. Also, the registration system is going to be more beneficiary focused because there was a lot of fraud last year where companies were kind of filing multiple registrations for the same person, but with different entities, that were related to the company. So that kind of goes back to the whole concept of needing a bona fide job offer, because obviously not every single company that was registering had a bona fide job offer. It had to be one that is, where the individual is actually going to work. And so to eliminate those multiple registrations, they are going to make it more beneficiary centric, which is nice because it means that more likely than not, everyone will have a greater chance of selection because there won't be as many registrations. And so basically this, the proposed rule is basically what I talked about. The goal of all of these changes is, from the government's perspective, to streamline eligibility, improve the efficiency of the program, provide benefits and flexibilities to both employers and workers, and to strengthen integrity of the system. So I do think that a lot of these changes are going to achieve these goals. What do you think, David, in terms of the different changes? Which one do you see as being the most advantageous?
Well, certainly the one that, the part that USCIS will be looking at each beneficiary instead of, each registration, that will certainly, deter, companies to put in multiple registrations to increase the chance. And also, I think that will give other beneficiaries, more fair chance of being selected in the lottery.
I agree with that. So Nodira and Amberley, do you think that in terms of all of these changes, are you feeling like individuals in-house like you are finding these updates kind of easy to understand? Are you familiar with them? Does it seem like they're going to be beneficial for you as the employer representative?
Yeah, I mean, I think anything that USCIS can do to strengthen the integrity of the lottery process is very important. So hopefully we'll definitely see that improvement this year, not see the fraud that we saw in past years. I think there's definitely concern, about the degree requirement being so specific and how that
Right.
will impact us, because degrees can be pretty versatile to different roles that aren't necessarily directly linked together. So I say there are positives and negatives about the situation at the moment.
Yeah, I agree. Okay, so here is something that I want to kind of emphasize is that complying with all these rules, I know we kind of went through them very quickly, and there are lots of changes, but compliance matters, because if you aren't complying with the rules, then you're going to be subject to fines, penalties for fraudulent practices. There have been a number of reports of LCA and public access file audits recently, making sure that people are working where they're supposed to be working, that their wages are correct, things of that nature. So it's very important. And I do know that it can be very overwhelming. So one thing that we've discussed internally is that, and from now until February, I believe it was February 9th, we had indicated, we are going, as a courtesy to the global mobility community and, F1 students out there who are trying to figure out where they're going to be working and how they can get their registrations done while they're wrapping up school or wrapping up their OPT. We will be offering, as a courtesy, consultations with no charge to individuals that have questions about any of this. And I believe the date, let me just make sure, it was through February the 9th. So yeah, February 9th, which is a Saturday, but preferably through the 8th. So with that, I would like to open it up for questions. If anybody has questions at this time about any of these changes or the process in general or qualifications for H-1B, you can go ahead and put it in the chat. I don't really see any right now. Let's see here. Let me see.
Cheryl, David, I'll ask you one while y'all are waiting to see if you have more questions. So we know that with the H-1B modernization, some things are still, to be implemented at a later date. Are there any insights onto when we might see that?
David, you want to take that?
Sure. So right now it's under review by the federal government. We do not know exactly when that will be implemented, but it is expected that it will be implemented pretty soon, especially those rules around the CAP registration. That I think the U.S. government is pushing for implementing them for this year, for the FY 2025 CAP registration. So that's right around the corner. So we might see some of these rules implemented very soon.
Okay, we have a question. It's kind of just more of a fun one, but it doesn't hurt to have a little fun with this. Otherwise, what can I say? Governmental topic. How many registrations do we all think there will be this year?
Too many. I'm kidding.
No, I'm expecting less actually, if it will actually be enforced, with like verification and I really, I didn't follow up on the last year. I heard from our legal counsel that there will be some legal repercussions for those fraudulent submissions. So I think it would be very, fruitful if someone would get a real slap on the wrist and paid huge fines, and then people would not do that. Or for the initial registration, you would have to submit a job offer for the person, and so there's no room to wiggle there.
Right. Yeah. I think that's the only way. I mean, hopefully these efforts will reduce the number of registrations. Quick question here is, will the cap fee increase from $10 to $215? And I think I already mentioned it, but I will mention it again, that no, the communication we've received from USCIS is that it will not increase this year. So while the other fees will be increasing, that registration fee of $10 will remain the same.
Until next year, right?
Correct. Yeah. So we have one more year of that inexpensive registration. So there's a question here. Is there a resource for employers to review the average waiting period by country? So in terms of by country, the H-1B isn't country specific, which is the conversation that we're having today. But in terms of waiting periods for visas, once the H-1B is approved, you can either look to the consulate where they're going for their visa to see what the wait time is. And so you would want to see specifically where they're going, and look to that website. And there's usually a drop down, and you just put the category, which would be H-1B, in the country or the city where they're going, and it will give you an estimated wait time for that, for the visa issuance. Does that answer that question? Hopefully.
I just wanted to add, if the question is about, green card, actually, and they can also look to Visa Bulletin that is posted by, U.S. government, updated every month, and that will show you what the priority dates are for the national specific, basically priority dates for each visa category for green card.
Thank you, David. Next question. Is USCIS changing documentation requirements to confirm that there is a valid job offer? As of right now, no, I don't believe so. Do you guys know differently? Have you heard anything in terms of documentation to show that there's a bona fide job offer? It seems to me, yeah, it seems to me that the effort of making it beneficiary specific is going to remedy that, right? Because they won't really need the documentation of valid job offer if there's only one registered, if the foreign national is registering as opposed to each proposed role at different companies. Okay, here's one for Amberley and Nodira. How are you planning to handle the new one entry, one employer rules for registration? In other words, how are you planning to ensure that your foreign national employees don't also submit an entry through another employer, thereby violating that rule? That's a very good question.
Well, our employees hired directly. I mean, Novelis does have multiple entities within the North America, but they all are hired directly. We are not dealing with third-party placements. So I think that that would probably pertain to those who are through third-party placements, staffing agencies. Our employees are all directly hired on a very competitive, I will say, basis. And Novelis is employer by choice. So it's like the benefits go on and on and on. So I do not think that we will have that issue at all.
So the one thing is that makes a lot of sense to me, what you're saying. And I do think that in my experience, usually people are very loyal to their employers who are willing to sponsor them. But I think the other way to wonder about this question is, what if someone isn't familiar with the new rule and they're kind of like hedging their bets? So like, I don't think you're going to run into this because, like you said, I think your employees are going to be very loyal and they're grateful to be working at such a great company, right? So, what if somebody is working at a different company? Like, what do you think somebody in-house could do to make sure their registrants are educated and understand that rule so that they aren't like job shopping and asking some other employer to?
Well, I think it's a deeper question because as an employee, as a human being, anywhere you go, any job you have, number one is a treatment, right? Is the flexibility, the treatment, the package of benefits, and your pay. Your pay is very important. Like in my previous career, I did service a third-party placement H-1Bs, where we had to actually reach out to an employer and say, hey, you guys are not meeting the minimum wage, requirement. So those individuals had to raise the salary. So in those cases where you see, although I think that even minimum wage sometimes is very high compared to a U.S. citizen holding the same job, but regardless, what I'm trying to say is that in Novelis, we do not have the situation of underpaid or pressured hours, low benefits or, hostile environment or any of that. So I think when the employees are happy with all of the above conditions, then there's no even point of shopping around and trying. And we, like I said, we don't even exclude anyone from request of, oh, please support us in H-1B lottery, for example, or sponsor us for green cards. So Novelis is supportive. Now, mind that it's not a huge population. We are not one of those where 50% or more of employees are foreign nationals. No, that's not the case. Our population is much smaller. Immigrant population or foreign nationals, I would say, population is much smaller within the company. Therefore, the package and the benefits are offered should you need one. I mean, as long as we are in compliance, like you say, we do review and anticipate and look for ahead, right? So even if people don't come and ask to get on H-1B list, either they're not aware or whatever, we propose because we want to continue to employ you. So I think that's not our case. So I do not anticipate that issue that people would be going somewhere else.
I think there are two ways really to look at that question. To your point, first, there's current employees, right? Like I'm not concerned that a current employee is going to have a second lottery submission submitted on their behalf, but there's this second bucket of workers that are, haven't started work with us yet, that we've submitted offers to, and perhaps their start date is after the lottery. I do think there is movement, I think from the law firm side, actually, that, when we do a lottery case, we are having the law firm send a questionnaire, right, to collect data from that new person so that we can submit them in the registration. I think there is an opportunity for law firms to add in a statement, that says by checking this box, you confirm that one, or like Micron Technology is submitting your CAP registration, something like that. I think there's definitely movement for that. In the same way that you would do dual representation at the beginning of the questionnaire.
Okay, so Brian's asking, what are some options for employees who are running out of OPT and are not ultimately selected in the lottery? So there are lots of different options, so one that we tend to fall back on initially is an O1, which is for people of extraordinary ability, but it is a pretty high standard. But we've had a lot of success with our O1 petitions. The other is to have, and certainly an employer wouldn't be advising this, but there is always the option of an individual going to work for a nonprofit. And if they if they are hired even part-time by a nonprofit, it has to be related to an institution of higher education and research. But there's an exception to the cap for those entities. So even if they're working for a nonprofit research organization or institution of higher ed, then they can concurrently have a for-profit cap subject, otherwise cap subject H-1B petition. So that's another alternative, is to see if perhaps they could have some sort of concurrent H-1B. There's a nonprofit organization called Open Avenues that actually will sponsor someone for even like 10 hours a week on an H-1B that would be not subject to the cap. And then those individuals can have a concurrent H-1B with a normally cap subject employer. So that's another option. Another option is sending them to an amazing destination and gain a year of experience abroad, bringing them back as either an L1 in a year, or having them, register for the H-1B lottery next year and see if they have better luck. One thing is there's lots of discussion about where to kind of park someone in those circumstances, right? Like, what are the countries or different, places where it's, friendly for them to get work authorization and be able to be placed if they're not returning to their home country. And so that's certainly something that we're open to discussing if you want to reach out and call. Those are all different factors. And we have partners around the world who can help with sending someone to a country abroad where, it would be favorable for a foreign national to kind of park until they are able to come back in on the H-1B or an L1 or other status. Overall, I think we were kind of talking about this. Do you feel that the new system is better than the old one, where we had to file a whole petition, like thousands of filings, right? Just like tons of thousands of filings lining the walls of the offices. I definitely believe it's much better, but would love to hear from you guys what you think about the new registration system as opposed to when we used to. I mean, certainly we're not, having the same rush of petition filings by the deadline, but I definitely find it much more manageable and a little bit more peaceful of a process. What do you guys think?
I agree. I think it's a better process.
Yeah.
Yeah, and from sustainability perspective, all that paper, I remember boxes and boxes and boxes, especially when you deal with third-party placements, all of those SOWs and MSAs you have to include. Oh, and now we are just avoiding all of that. Imagine the officers' labor too, like to review that mail rooms.
Oh, the mail room must have been awful.
Yeah,
it was definitely. Yeah,
if you do the job offer, legit job offer, and company documents, and have a registration, is just so much more efficient.
I think so. Even though it was a little crazy in terms of the numbers, I think it ultimately, as it kind of shakes out, I think it's going to be much better. I always tell people the funny thing when my son was in kindergarten, that they had to learn the letters of the alphabet, and they were learning the letter H, and the teacher asked, does anyone know what starts with the letter H? And he said H-1B season. And so it definitely took over our lives at home, at work. It was just, so when I picked him up, she was like, what is H-1B season? And I'm like, well, you don't want to know. But definitely much more manageable now. Okay, so Noah's asking, Amberley, Nodira, have you typically utilized the parking option for individuals not selected in the cap, or what are your alternatives that you've used in the past when people aren't selected?
Yeah, we do it regularly. That is our regular, I would say, preferred path is when someone's not selected in the lottery and they're maxing out of U.S. immigration. We do send them abroad to another site for a year. My team manages immigration all over the globe, so not just the United States. So it's pretty seamless for us to, secure them a work permit in Taiwan or India or wherever. Micron has another facility. And then we do a couple of things. We'll initially plan to get them an L to bring them back, but we'll also still enter them in the lottery. And if they have a green card in process, we'll continue to process their green card. Using the term parking, we tell them it's a little detour on their U.S. employment. Not to minimize it, but just to try to make them feel better about it. It's a detour. They'll get, experience abroad with the company, which is really valuable. And then they'll come back.
Same
question someone asked also. Oh, go ahead, Nodira. Sorry.
I was going to say same thing. Like this morning, for example, I was screening with legal counsel a candidate for a job, who was about to be extended an offer. And right after the call, I sent an email to a hiring manager saying, if you select him, let me know ASAP, because I'm sending the H-1B cap list. So people are enrolled every year until they're selected. And if they are not selected, the prior question was the same thing. If they are timing out, then we do have entities around the globe where we do send them on an assignment for a couple of years minimum, and then we bring them back on L.
Nice. One question that has been asked, what would, for Nodira and Amberley, what would be your advice for employers who are debating on whether or not to even register an employee?
Oh, I say register them.
Mm-hmm.
You don't have to commit to filing a petition, but register them. It's a lottery. Give them that chance, and then have that deeper conversation later.
Yeah, I agree. I think with the challenges that we're currently experiencing, finding the right talent, especially in our industry, we need scientists, we need engineers, we're expanding everywhere. So if we have the right talent, it's never a question. Just put them.
Right.
And because it's hit or miss, and it could be not selected twice, 2 years in a row, and they're not selected. So then you're encountering more expenses of how to save them by sending them on an assignment, so.
And also, if you're wondering about, the legal requirements that can be met for that particular person and the position, reach out to us, and, we can review, we can, discuss about the requirements, and we can assess whether H-1B cap registration would be advised for that person.
Yeah, so I don't see any other questions. I'll leave it open for a second, but I do definitely want to thank Nodira and Amberley for joining us. It's always important to us to have the perspective of the, global mobility or HR professionals who are working with the company, because, they definitely are always seeing things and managing things that we aren't, so I definitely want to thank you for joining us today. David, always thank you. And excellent insight and great job. So does, I guess, anybody have any other questions or anything else we'd like to add before we wrap up?
Good luck to everyone, and I hope everyone is selected, or majority selected.
Same. Think positive thoughts. All right. Well, I think that's it. So have a great day. We only have like a minute and a half left. So we kind of, I think, reached our time. And appreciate everyone who joined. And reach out if you have questions, for sure.